Good afternoon. I'm George Chadlick, graduate of St. John's University School of Law in 2007, and I'm an LLM student. And today we're here to interview Len Rosen, who is the founding partner of Wachtell Lipton, Rosen & Katz, and also the leading figure in the modern-day bankruptcy. Here with us are also Professor G. Ray Warner, who is the director of the LLM program at St. John's, and Professor Robert Zinman, who is the founding director of the LLM program.
Maybe we could start off with you. You grew up in the Bronx?
Yep.
Where in the Bronx?
I grew up on Walton Avenue, essentially, near 165th Street, which was around 4 blocks from Yankee Stadium, and it was a great place to grow up.
My wife's aunt lived on Walton Avenue in the Bronx.
And we had wonderful playgrounds, one of which is being torn down for Yankee Stadium, the Coombsdam Park and Mullally. And I played a lot of basketball, stickball, the usual street stuff. As a matter of fact, I belonged to one of these social and athletic clubs that were prevalent in those days, and we still have about 10 or 12 guys from that club who have lunch together once every month or two. So it was a wonderful place to grow up.
And you went to school?
I went to the local public schools, then William Howard Taft High School, which was not a renowned high school for academics, and then I went on to City College. I was a commuting student from the Bronx to Manhattan. I majored in accountancy. I went uptown. In those days, you went to uptown CCNY, which was the liberal arts area, for the first year and a half. Then you went downtown to Baruch, which was the business school for the rest of your career. And so I majored in accounting. And thereafter went into the Army. Because of my accounting background, I was in the Army Audit Agency. And I audited contracts out of the Baltimore office of the Army Audit Agency for 2 years. So well, I skipped law school.
Oh, what made you decide to go to law school after studying accounting?
I felt like one of the careers I might want to pursue is a tax accountant, and that in order to be a tax accountant, that law school would be worthwhile. And it was only after I got to law school and did reasonably well that I said, well, maybe I ought to try law rather than accounting, and I found law much more interesting. So my career objective changed in the course of law school. I got onto law review at NYU and did well in my grades, and I felt like I could do that. And
when you graduated?
When I graduated, I went into the Army Audit Agency for 2 years, which again was a mixture of accounting and law, reading contracts and doing auditing. And it was a great job in the sense that I traveled between Virginia and Maryland to various manufacturers who had contracts with the Army, and audited their contracts and came back to Baltimore on weekends or whatever. So it was good duty. And then when I got out of the Army, I started looking for a job, which was 1956. And it was a time when NYU was not yet really recognized as one of the front-running law schools, so it wasn't that easy to find a job. I finally found a job with a small firm, which was Seligson, Morris, and Newberger. I did interview at some of the larger firms. They were interviewing at NYU, but they weren't hiring much from NYU. And Charles Seligson was a professor at NYU. I never had him while at law school, but it was a wonderful career start. I was very fortunate. There were only 6 people in the firm, I think, at the time. Seligson was a litigator, but also a bankruptcy person. He had been one of the attorneys for the receiver of Irving Trust during the 30s and 40s when the bankruptcy ring was broken up. He was a co-author of Collier. He was a very scholarly man, came from North Carolina. He was a Southern gentleman, very polite and reserved in his ways, very capable man, and was a good mentor.
How was it working with him?
He was fun. I mean, he was a very serious person. He was extremely capable. He would dictate briefs rather than write them, and he wouldn't have much revision when he finished dictating. He was good in the courtroom. He had a very good manner. He was good with the associates in the firm, and it was an enjoyable guy to work for. The firm was so small that I did work for him. I also did work for the other two partners. So for the first all my years at Seelix and Morris and Newberger, I did both some creditors' rights work. Morris was a corporate lawyer that I'll talk more about if you want. And so I did some corporate work, and Newberger was a sort of estate planning, estate kind of lawyer. So I drafted wills, I drafted contracts, I drafted loan agreements, and occasionally went to court. It was an exciting experience. They were all very talented, generous people, and it was a great experience.
You hired Harvey Miller.
Yes, I did. It was one of the great things I did, actually. He probably is the icon you're really looking for, but we had a case called Jane Lee's Stores, which was a typical garment center chain of stores that was in trouble. An honest proprietor, which was a good thing in those days, and Harvey represented, he was with a firm called Ballant Stoll, and it wasn't Itzler then, but it was something. And we were representing the debtor, and so I worked with him in the course of that, and we got to be somewhat friendly. And then he said, I think Otterberg was making him an offer, or somebody was making him an offer. So I spoke to the professor and I said, you know, this guy's good, we ought to make him an offer. So we did, and he came with us. And he remembers the story that, although I don't remember it so well, we had a case called the Sire Plan, which was a Chapter 10 pending. One of these real estate developers, he wasn't really a developer, he would buy real estate and then sell partnerships, but he basically was a crook. And so he wound up in Chapter 10, and we needed a lot of help. We were really swamped. So we told Harvey, this is what he remembers, this is a temporary job. It may not last beyond the Sire Plan case, okay? But he came, and obviously other cases came, and it lasted beyond Sire Plan, and it was a great working relationship. Ben Weintraub was a partner in a firm called Levin and Weintraub, which at that time was a boutique, what they call a boutique Chapter 11 firm. It was the boutique Chapter 11 firm in the city. There were a couple of others, but his was heads and shoulders above the others. Ben was a very scholarly person, sense of humor, easy to talk to, good for dealing with younger people. He was just a pleasure. Harris Levin, his partner, was again a little more distant, a little more scholarly, a little more reserved, harder to deal with. But the combination was great. And eventually Mike Crames joined that firm. Mike was Ben's son-in-law, I guess, and that came Levin, Weintraub, and Crames. Those boutiques are disappearing, have disappeared pretty much. They've merged into larger firms. The world has changed quite a lot from those days.
And Ben Weintraub was the co-author with Professor Alan Resnick in the famous treatise on bankruptcy.
Yes, and both of them very scholarly. And Alan is still at, I guess, Hofstra, and has been very active in the Rules Committee. I mean, they're both very, very honored people.
One side question, where was the bankruptcy court at that time?
It was in the federal courthouse in Foley Square. I think it was the second and third floors. Bankruptcy referees had their own, but they were referees at that time.
And they became bankruptcy judges in 73.
With the 78 code, right.
What do you think of the new court system? Is it constitutional?
I tried to prepare for this to some degree, and I went back and read some things where somebody did an analysis saying it's not constitutional. They haven't really changed, they haven't really solved the marathon problem, but I don't really have an opinion about it, honestly. It's been functioning now since Marathon and since the legislation that allegedly fixed it for 20 years. So,
well, I recall one incident that I'd like to just recount because I think it's one of the most significant contributions to real estate in bankruptcy of anything that has ever happened. And that was your contribution of 11B. I remember that so well because I was kind of the new kid on the block, and I was invited to this meeting because we had tried to overcome the Pine Gate rule with respect to real estate, and the object was we would have absolute priority for the unsecured claim, and it was the unsecured absolute priority for dissenting impaired creditors, and it was the absolute priority for the unsecured deficiency claim of the mortgagee that would protect them. And then we realized that there'd be no secured deficiency claim because the loan was non-recourse. And there was this big meeting in John Creedon's office. All bankruptcy experts there to discuss the situation. Everyone agreed it was a real problem, and no one could think of a solution. And then there was a break, and I remember we were standing in front of the, I remember it distinctly to this day, because it was like a road to Damascus moment. We were standing in front of the fireplace, and you were standing to my right, and everyone was bemoaning the fact we didn't know what to do, and you said in your usual modest, unassuming way, do you think it would help if we converted the non-recourse claim to a recourse claim for the purposes of the cram down? And that was it. Harvey Miller says you always cut the Gordian knot, and you sure did that.
Well, I don't have such a strong recollection of it. I've always been interested in the confirmation issues, and I think that was one part of the confirmation issue, and the other part was getting away from the Chapter 10 standard and going to the new Chapter 11 standard. And on that one, I think your recollection may be right, because I remember we did that in the meeting of lawyers, bank and insurance company lawyers, who were worrying about those non-recourse claims. And so I think 1111B was a good idea. It seems to have worked. It seems to have prevented the in effect, cram downs against secured creditors based on values that were just appraisals rather than marketplace testing. And that was the evil of Pinegate, that your judge would in effect get a case and somebody bring him an appraisal and say this is all it's worth, and the secured creditor be stuck to that amount and lose the balance of his money. And the 1111B forces a sale and in effect gives the creditor a claim for the non-recourse portion, so it prevents that kind of cram down by valuation against the secured creditor. So I think it was a good idea, and it seems to have worked. While talking about that, I can talk about the other idea, which brings up a couple of other old timers, Homer Kripke and Peter Coogan. I mean, when I was in the NBC, there were some young Turks, I was one of them, who were agitating for something other than the old Chapter 10 standard, which required a valuation hearing every time you did a plan. And that involved enormous delay, a huge amount of litigation, because every class had their own expert saying the company's worth X, another one say Y, another one would say Z, and valuation was an imperfect science. That was Peter Coogan's point. It's an estimate compounded by an estimate. Peter was a professor at Harvard Law School, but he also was a practitioner at Ropes and Gray, and he had this ability to see both sides, to see the academic side and what the real world was like. And Homer Kripke, who was a professor at NYU, who had 3 areas of expertise, which is extraordinary. He was a securities lawyer, he was a creditors' rights lawyer, he was a code lawyer. And so he really brought a lot of perspective to these things. And he was a commissioner of the SEC at one point, professor at NYU. He practiced law in New York. And so he also recognized the practical difficulty of the confirmation standard under Chapter 10. And the two of them were members of the NBC. And we had Vern Countryman there, who was a professor at Yale, I guess.
Well, Harvard
originally.
After James Angell McLaughlin.
I'm sorry, it was Countryman, and Countryman was an adamant advocate for the absolute priority rule. He didn't think you could ever do anything without having the absolute priority rule and evaluation every time, like the old Chapter 10. And within the NBC, it was hard to overcome him because he was a very forceful guy and very well respected. But some of the younger guys, we got Coogan and Kripke on our side, and we had a lot of the younger people on our side. And in effect, that was, I think, the key thing that I saw coming out of the 78 code. The shift in the confirmation standard to a standard where you didn't have to have an appraisal every time. You let the parties negotiate. If they could make a deal, you didn't need a judge confirming what the company was worth. And that enabled cases to go through much more easily than they otherwise would have. One of the problems with the old 10, you know, bringing back memories of 10 and 11. We used to file 11s. I mean, when I filed, we represented W.T. Grant, we filed an 11. Nobody wanted to go into 10. You felt like you could never get out of 10. Valuations would take years. Litigation would just take lots of time and money. And so you went into 11, and then you hoped the SEC didn't move you over to 10, and it was you had to talk to the commissioner, you know, to someone at the SEC every other week to convince them that, well, we're going to do the right thing in 11, don't push us into 10, because that's going to be a disaster. When the code came, they stopped that. There was only a single chapter and a single confirmation standard. The absolute priority was still there, but it was only there for instances in which creditors could not agree. So we set up a platform where creditors could agree, avoid the valuation, and get out relatively easily. If they couldn't agree, you would wind up with a valuation. And that, I think, has worked successfully. I think that, to me, that was the biggest change. At that time, people were starting to realize that the time value of money is a big issue here. In other words, you had people starting to buy claims, which now has become rampant. You can hardly find people who originally made the loan in anymore, because they've sold out. But in those days, it was beginning to happen, and the people who bought claims said, well, I paid $100 for this $200 claim. I'm now looking at whether I'm going to make money on my $100. And if I have to be in a 10-year litigation, no way I'm going to make money on my $100. I want to have a process that deals with this relatively expeditiously. And I think that's what the new code did. It permitted expeditious process to get to confirmation. So that I feel like was something I worked on that was important.
It certainly was. You mentioned W.T. Grant. You were representing the debtor,
yes.
in that case.
Yes, that's probably, I don't want to say it was the first, but it was the last time probably. I think I concluded that in order to do debtor cases of size, you really had to have an army. And we wanted to remain as small a firm as possible. The philosophy of the Wachtell firm is something we can talk about, but the philosophy was you don't want to get too big. You want to just have a high quality work, high quality staff, and be able to charge proper fees so that you didn't want a volume of work that was low fee. You wanted to be in that range, and so it was better representing creditors. And thereafter, we just focused on institutional creditors in terms of the creditors' rights practice.
It's probably the most successful firm in the world. And so that was probably a good...
It was a good strategy. I think it was a good strategy. Yeah, we only had one criteria. The criteria in taking matters at this firm was what is best for the firm. And that doesn't work at firms where you have compensation systems where your compensation depends on what you bring in. I can go through the transition from Seelig and Morrison Newberger to Seelig and Morrison Newberger was, I got there in '56. Marty Lipton came, who had been NYU class of '55. I was NYU class of '54. He came in '57. A year later, he had been clerking for Judge Weinfeld. We were on review together. And when I got out of the Army and I was looking for a job, I went to see him. He was clerking for Weinfeld. And he had worked a couple of summers at Seelig and Morrison Newberger, which was a small firm. I don't know how he got there. And he said, why don't you go talk to them? So I went to talk to them. After 2 or 3 months of looking, I had one prior offer, which I declined, and I got the job. It was a great opportunity. Seelig, I described. Morris was a frustrated actor, great lawyer. He loved to declaim Shakespeare. We'd be going down a court or something, and he would be reciting from some play. He treated us like sons. He didn't have any children. He was married, and he would take us shopping and buy us shirts and ties, and he would take us to 21 to try to teach us how to deal with clients, and he was just a wonderful guy. They really came out of the Depression, and you don't want to grow too big, and that firm never got to be more than 7 or 8 people. And he was the sort of guiding kind of genius of that firm. And we had as clients in those days Shenley Industries, Metromedia. We couldn't do a tenth of their work, but he had the relationship, so we could do any part of their work that we wanted. And we would associate ourselves with other firms when we needed, heavy labor. And he just felt like that's the way he wanted to be. He liked that. I'm going to start. Great.
Len, I understand Mr. Morris wanted to stay small, and that wasn't quite what you had in mind. You want to tell us a little bit about how you created the Wachtell, Lipton & Rosen firm?
Okay. There came a time, I guess in 1965, I think I've got it right, when we were feeling, and I think Marty particularly felt like we had to grow. And the philosophy...
That was Marty Lipton, right?
Marty Lipton, and the philosophy was somewhat different from what Jay Lincoln wanted. And so we, in effect, 3 of us said we're going to break off. And we decided to join up with Herb Wachtell. Part of the philosophy under the old firm was you get co-counsel when you have a matter that's a little too big for you. We had gotten Herb Wachtell. He had a small firm called Wachtell & Kern, and Herb was a 54 graduate, my classmate. And so we thought we'd ask him if he wanted to join us to form a single firm when we broke off. So we had this famous meeting we were looking for space, and there was a building on Lexington Avenue where there was a small, I think it was a lawyer's office on the top floor, and we all went up there one night, nobody was there, and sat around the table and talked about what we wanted the firm to be like. And I wish I had notes because I'm going to leave something out, I'm sure, but we said we wanted it to be a meritocracy. We wanted to hire only people that we thought could become a partner, that we would never engage in business with our clients. It would be purely a professional relationship, that we would take vacations, which is the one thing we violated, that we would share compensation equally, essentially, and that led to our firm having a step system which persists to this day, and that we would treat our employees generously, pay them well, so they can come in well-dressed and be happy, and that we would not look for a volume of matters, we would look for large matters of consequence which could justify good fees. And that matters taken would be the best matter from the firm's point of view. And one of the things people don't realize, and maybe they do realize it, is that if you have compensation triggered to your own production, you have competition for the internal resources of the firm. Then you want associates to work on your matters. And your matter may not be the best matter from the firm's point of view. So what it does is it really creates a problem in terms of the future of the firm, because you're not necessarily working on the thing that's best from the firm's point of view. And we've always had our eye on that ball, and that's a very important ball to have your eye on. But you have to have, I think, and people within the firm probably disagree with me, the step system, I think, is a very important part of that, because your compensation doesn't depend on it.
Now that split really created 2 of the leading bankruptcy firms as we know them today. And if you go back and think about what might have happened if things had been a little different, you and Harvey might have been the same firm, but how did that occur?
Well, there was this cab ride, which I think I described, and I think Harvey felt a special loyalty to the professor and wanted to stay with him. And so
you and Harvey and Professor Silligton were in the same
we
cab.
were in one cab coming up from the courthouse, and we were trying to persuade him to come with us to a new firm. And
so Harvey's original thought was to join with
join with us, but he wouldn't do it without the professor. Absolutely right. And but the professor declined, and so we split, and we went off with Wachtell & Kern, which was this other small firm. They had 3 people. They came. 4 of us left. It was myself, George Katz, who was with us at that point, and Marty, and Ted Gewirtz, who's still at the firm. And so that was the split. And they continued for a couple of years, but at that point, it was a coincidence, the Ira Haupt case was pending at that time. Ira Haupt was a salad oil scandal in New Jersey, which somebody had warehouse receipts, American Express subsidiary issued warehouse receipts for oil in tanks in New Jersey that wasn't in the tanks. And a man by the name of Tino DeAngelis was the author of that particular scheme. And that case came in to Seelig and Morris and Neuberger shortly before we left. And Tino wound up going to jail. But when we left to form our firm, about a month later, was having dinner with my wife out on Long Island, and Frank Musselman, who was a partner at Millbank, wonderful, wonderful man, was having dinner with his wife in the same restaurant. So we wound up sitting together having dessert together. And Frank said, "What are you doing?" So I said, "Well, we just started this firm," and I went through this whole thing. He said, next day I get a call from Frank. He said, "You know, I've been representing the English banks in the Ira Haupt thing in addition to Chase. Chase was their regular client." So he said, "I'm not comfortable doing it. Will you guys take over the English banks?" So that was one of the first nice referrals that we got. Millbank was really a very open firm to that kind of thing. That was terrific. And so then we represented the banks in the Haupt case. The Haupt case went on for years and years.
Now,
and Charlie was the trustee at Seelig and Morris and Neuberger. Harvey was there, right. And then they worked closely with the Milstein, with Walgaccio on that. And then maybe a year or two later, they decided to merge with it. I think Morris retired completely. He became ill. And it was just Charlie and Harvey and a couple of other people. And they basically went to Walgaccio. But we had left already, and they went to Walgaccio a couple of years later. But they already had a close working relationship on the Haupt case, so that was the outgrowth of that.
Now, you're also very well known for one non-bankruptcy case that I think everybody thought would become one, the Chrysler case.
Yes.
And I was just wondering if you could relate a little bit of your recollections of some of the things that were exciting about that representation.
Well, that was a fascinating case. First of all, it was a workout because people felt that an automobile company couldn't go into a bankruptcy and survive, or even a Chapter 11 survive, because who would buy a car if you weren't sure that they'd be there to, on their warranty? People used to think that about airlines. Who would fly in an airline that went into Chapter 11?
And they say restaurants. Who would eat at a restaurant in Chapter 11? But,
all right, but it works. Restaurants and airlines have worked, more or less, although some airlines have gone 2 or 3 times. But no car company, I guess, has gone in that I know of into a bankruptcy proceeding, and maybe one wouldn't survive. But that was the theory in those days, and the government came up with this guarantee, and the guarantee had a lot of conditions to it, and it sort of put the wood to the lenders that they had to make sacrifices in order to have the guarantee exist. And one of the things about the practice that we developed at this firm was that we were in a sense, a boutique firm to back up the regular counsel to institutional lenders. And what happened in those cases is you would have, and in Chrysler it happened, Manufacturers Hanover was the agent bank. And there were a number of different agreements. Insurance companies were in that, banks were in it, there were domestic banks, there were foreign banks. And it was very hard to get the whole thing organized. Manufacturers put on a real effort to get it organized. But it became helpful to them to have a different counsel represent the group as a whole than their own counsel, which was Simpson Thatcher. And that became something that we did a lot of. In other words, we were brought in by Continental Bank, even though their regular counsel was Mayer Brown and Platt. We represented Continental with Mayer Brown on a lot of matters. And so we did a lot of that co-counsel kind of thing where there was a big group involved and the other banks maybe weren't completely comfortable with just the agent bank's counsel. And that was a prime case, and that was a huge effort. I mean, we used to go to Washington every week to meet with the Treasury Department to try to make sure that we were complying with what they wanted. There were all kinds of different feelings among the banks about whether this was a smart thing to do. Should the government step in and help Chrysler? One of the major banks at one point got me to go to a special meeting with an outside consultant that they hired to demonstrate that the K car could not make it. The K car was the car that Chrysler was then developing, and they had to bring it to market, and that was the thing that helped us get the K car to market. Well, eventually got to market. It was not a very successful car, but you know, I went to this meeting, and this bank was convinced that this should not be done as a philosophic matter, and it should not be done as an economic matter. And on the other hand, other banks felt like it had to be done. So the problem became, you know, how do you reconcile these different points of view within the lending groups? And I realized from that experience and other experiences that I came up with my own definition of leadership. Leadership is not what you think of by being the first one across the line in a charge. Okay, leadership in workouts, where basically you need unanimity. You need everybody, okay? So what you've got to do is develop a strategy that leads to a consensus where it becomes overwhelming so that even if one person doesn't really agree, they're going to go along. And the first thing you learn is you don't call it an executive committee. You don't call it a steering committee, okay? You call it a working group. Okay, it's just psychology. I mean, I guess this is a little bit me, because that's what I believed in. And as soon as you get a working group, you decide what has to be done, the tasks, and you have committees. And everybody can volunteer for the committees, and you can volunteer for the working group. There's no hierarchy. We're just a bunch of workers, and we're trying to get to the best solution. And over time, given that you get people to work on problems together, and given that you listen to the committees when they come forth with suggestions and proposals, you can build a sense of, you used to be able to build a sense of community. So that in the end, somebody, even if he wasn't sure you were right, if the vast majority wanted to do it, they would do it. And that's how we did them. I mean, there were a bunch of them like that, and it basically worked. But it's time consuming. You got to be there, you got to meet, you got to nurture things along, you got to see where people stand, get a sense of everybody's point of view, try to keep everybody reasonably happy, and sometimes you get a result. I mean, you don't always get a result.
You were the chair of the National Bankruptcy Conference, and probably the most exciting period in at least contemporary bankruptcy law. 1984, you became chair, and I wonder if you could relate to us a few of your perceptions of what was going on at that time in the bankruptcy world, and the role you played, and frankly also what the National Bankruptcy Conference was and the role it played at that point.
I'll try. Let me describe it generally, because it's hard for me to pinpoint when we got into different things in the NBC. And particularly when I was chairman, most of what I did was making sure the hotels had rooms for everybody and the dinners were served and everything else. That was the function, essentially. But that also speaks to the leadership role. In the NBC also, leadership is not leading. Leadership is seeking a consensus and taking care of the details. That's what it is. So. But the NBC is an organization of about 60 some odd, generally speaking, practitioners, professors, judges, who are interested in the administration of bankruptcy laws and the content of bankruptcy laws. It's been in existence, I think, since the 30s. It really tries to have everyone leave their client at the door, their own prejudices, their own financial interests at the door, and come together to have a rational, objective discussion of what is a good bankruptcy law. And I think that they succeed in that, in the sense that people who are advocates for creditors outside or advocates for debtors outside come together, and while they may express the points of view of their normal clients, the effort is to reach a reasonable kind of accommodation of the competing interests. And they do their best to be available to Congress to assist in the drafting of legislation. They will criticize drafting and make suggestions to simply accomplish the purpose that Congress wants to accomplish. In the last few years, very often the legislation is written by lobbyists and doesn't work. So, like this last bankruptcy, BAP-CAP, whatever. I mean, we had
2005 amendments.
2005 amendments. I mean, that put us to work coming up with a long list of just corrections, not changes of anything, just trying to make it work.
So you found that in more recent times, Congress is less receptive to sort of dispassionate input from...
Completely.
And tell Bob.
Completely.
Tell Bob, Mr. Rosen. Repeat the question, Ron.
You found in more recent times Congress is less interested in the input from dispassionate, non-advocacy type groups.
Absolutely. There's no question about it. That recent bill was paid for by lobbyists on behalf of credit card companies who were concerned about their ability to collect their money. And the fact that most people who get into these problems are not crooks, some probably are, but most of them are victims of divorce, disease, loss of jobs, and need help. And they've made it much more difficult for them to get help. And the amazing thing about the NBC is that the lawyers in the NBC all work for institutions, but the NBC has continuously fought for the consumer in this. The lawyers to the banks and insurance companies are not there on behalf of this legislation, but the lobbyists are, and the officers of the banks, obviously, or the credit card companies, want this result.
Have you seen a similar sort of advocacy model showing up in the legislative changes on the business side?
On the business side, it's been better. I mean, the real estate interests have always been troublesome in the sense that they always want to get their property back right away, and it's more of a known quantity.
That's my friend Bob here, right?
Well, yeah, but it hasn't been as devastating. I mean, when you're dealing with business interests, it's just not that bad unless you destroy Chapter 11. But when you're dealing with consumers, and you're making it hard for people to go into bankruptcy who can't stay out in a way, and that's a big problem. I don't think the business problems are massive problems. Also, the judges figure ways out around the business problems, so they temper what's done in the code when you deal.
Well, I want to take you back a little bit to 1984 because it was an exciting time in bankruptcy, and wondered if you could talk a little bit about what the National Bankruptcy Conference and you were engaged in at that point in terms of the reform efforts.
I think that we were really trying to digest what had already happened. I mean, the code had gone into effect, I guess, in 81, 78 code, and there was a lot of action on the rules at that point, trying to modify the rules to get it. Actually, I was a member of the Rules Committee, I think, through that period, trying to draft rules. I don't really remember us doing any significant work on the code itself. I think the feeling was the code was a pretty good job, and it would need touching, but you didn't want to touch it too soon because it was always a problem to start talking with Congress about making changes. You never knew where they were going to go. You may have wanted these changes, but those weren't the ones that occurred.
I was wondering if you could talk a little bit about your perceptions of dealing with Congress and of some of the changes that occurred under the old act and its shift into the new code.
Yeah, that was a much better time from the point of view of legislation and having a decent bankruptcy code. I mean, there was a Manny Sellerin, congressman from Brooklyn, who was chairman, I guess, of the relevant subcommittee in the House.
He was my congressman.
He was your congressman, okay. And subsequently, Rodino, who was a congressman from New Jersey at the time the code was passed. Edwards, I don't remember their first name.
Don Edwards.
Don Edwards from California. These are men who took an interest in seeing that the legislation was a reasonable legislation, that this was a proper thing to do, and they instructed their staff accordingly. And the staff at the time that the legislation was being drafted on the Republican side was Ken Klee, on the Democratic side with Rich Levin, both very scholarly, bright young men, ambitious, both now significant practitioners in the field. And they balanced each other. I mean, one had a conservative point of view, one had a more liberal point of view, but they together drafted the original code, and they did a good job. And it was really about finding something that worked, rather than listening to some lobbyist as to what banks wanted or insurance companies wanted or unions wanted. I mean, it was trying to do what was right.
I guess, more of a negotiation standard with the threat of a judicial valuation hearing if that failed. I was wondering if there were other things that you can remember that were particularly important shifts in bankruptcy, problems maybe with practice under the Act that you were trying to correct as we moved into the code, the role of secured credit, things like that, if there were things that come to mind.
The thing that comes to mind is the mass tort problem. I mean, I became involved in a case involving asbestos liability, and but I was interested in it before then. The fact that the whole problem of asbestos liability and other mass tort situations, the Dalcon Shield situation, they wind up in bankruptcy court because there's no other place that can deal with them. And yet the bankruptcy code makes absolutely no provision for these things. And the judges and the lawyers have had to try to find places where you could do things with the code that go beyond the code literally. And we're still struggling with that because Congress, in all its wisdom, even though they've had a number of commissions give them suggestions with respect to how to solve this problem or try to solve it, they've not acted on that problem. They've acted on what they've been pushed to act on by others. So the mass tort problem is a problem that's still there, still lurking. It still needs amendments to the code to really make it work, because there doesn't seem to be any kind of solution that works outside of something like a bankruptcy proceeding.
Well, I guess that raises a different issue too, is obviously you were involved in the drafting of the code, but since the code became law, lawyers like yourself and Harvey Miller have been very good at creating new things that others didn't see in the language, mass tort being one example. And I was curious sort of if there were any others that you can think of that come to mind as particularly creative uses or surprises that you may have had about how the code ended up being used and the process of Chapter 11 in sort of the early phase to maybe mid-phase after the bill became law.
I can't think. I think the mass tort thing is the biggest thing. The other kind of thing was this business of paying some claims in a Chapter 11, even though they were pre-petition.
So the critical vendor kind
critical
of idea.
Vendor idea.
Rule of necessity.
Rule of necessity. Yeah, that's a point of controversy. That could be clarified, and that one has disturbed me. That in the Dalcon Shield case, for instance, they tried to pay women who admittedly had been injured some money out of the fund before the plan got confirmed. But it was a sensible kind. It was obviously a sensible kind of thing. Somehow the court couldn't get there. But in subsequent cases, they've managed to pay all kinds of creditors on some theory that they're critical vendors, they're critical lenders. I was always very interested in the issue of rolling up pre-petition debt into post-petition debt.
Which they often do in a DIP loan
context. Which they do in a DIP loan context. What's the standard for doing that? That has always disturbed me. It can be done properly, but to do it in a blanket way is not proper. You have to value the collateral and do it in a way that gradually perhaps rolls it up, but only to the extent that the creditor was in fact secured previously. If the creditor was unsecured previously, there should not be any way to turn something unsecured into secured. So that's a place where it could be tightened.
Now, we hear a lot of discussion internationally on rescue culture, and we're seeing right now other developed countries adopting systems that look somewhat similar to our Chapter 11, as we seem to be shifting a little bit away from it. Were there any discussions of rescue culture, or was that a driving concern in the shift from the Act to the Code? The idea of a Chapter 11 process that really aids in reorganization and concerns of that sort?
We didn't talk about it in that terminology, honestly. I think we thought Chapter 11 should be the way to go, and that you needed a defined way to do it. That there was that there were going to be standards in order to get through it. That you weren't going to just do it willy-nilly. And I never went beyond that. I once did a paper for a discussion on something dealing with the RFC, the Reconstruction Finance Corporation, which during the Depression was a corporation created that had some power to, in effect, adjust mortgages. It's the kind of thing that's probably needed now. But I never felt that there was going to be a way to do that was a solid in a statutory constitutional way. I think the bankruptcy code goes as far as you can probably go without getting yourself into trouble. So you could maybe come up with some provisions in 11 that help these debtors possibly with mortgages, but you know, I don't remember any discussions of going beyond the framework of the kind of thing we talk about in Chapter 11 and straight bankruptcy in Chapter 13. I mean, Leon was just one of the great talents in bankruptcy. I mean, he was a very engaging guy. He just died about a year ago. He was active until his death. He was as sharp as he ever was until his death. He was a very hardworking. He was really a wonderful member of the NBC, a wonderful member of the bar. I mean, he was just a scholar. He was on panels forever and ever, Aliaba panels, all kinds of panels, and he always acquitted himself very well. He'd come to the National Bankruptcy Conference meetings completely prepared. At the age of 80, I mean, he was an active participant in issues that interested him.
I was also wondering about Ron Trost.
Ron is a friend, so I'll be careful what I say, but he's a Californian. Texas Californian. I guess he was born in Texas, maybe. But he is a brilliant lawyer. He very hardworking. If you're working on a case with him, I worked on the Chrysler case with him. I think he was on the Chrysler team. If he called you at 10:30 or 11 o'clock at night, that was nothing. I mean, it was like you're lucky he didn't call you at 2 o'clock in the morning. I mean, when he needs an answer to a question, he needs it immediately. But he gets things done. He's very creative. He's just a wonderful personality, and very enjoyable to work with.
Can we ask you about a few of the well-known, famous people that you knew during your career in bankruptcy? How about George Treaster?
George Treaster is a very unique, talented individual. He's still alive. He doesn't like to fly, never liked to fly. So he lives out in California. I think he lives in Southern Oregon or Northern California. He taught almost all of his career. I don't know if he's still flying down to LA to teach, but he's absolutely brilliant scholar. He was the kind of person who at NBC meetings, you'd raise some esoteric point, and George would be on it and would know the background and know the point and know the cases. Just a legendary kind of person. Mm-hmm. Very gentle kind of personality, very soft-spoken, but when he spoke, you listened because you knew he knew what he was talking about. Just a charming, wonderful individual. Good tennis player, too, but great guy.
Well, your family.
My family, that counts. He's got a son who plays tennis also.
Connie Duberstein.
Connie was a marvelous character. I mean, just a wonderful storyteller. He was fun as a practitioner. He was wonderful as a judge. I wondered when he became a judge what kind of judge he would be. He turned out to be scholarly. He turned out to be very good on decisions and everything he did. And he's just a wonderful human being. The story I tell about Connie is we were in a food fair case together. I think I was representing insurance companies and he was representing the creditors. And in those cases, it was before the code, I think, and in order to form a committee, you had to have these meetings of creditors without the judge being present, and they basically could be a scene. Because the question is, the debtor would come in and tell you, well, this is the problem we have, and we had to go into Chapter 11, and please work with us. And then the debtor would leave the microphone, and if there wasn't an obvious, very large creditor to give it to, somebody would walk up to try to run the meeting. Sometimes more than one person would walk up to try to run the meeting, and it was not fun. And that's one of the reasons why in the code it was sort of regulated that the U.S. trustee appoints the committee. Mm-hmm. Who is the committee was a big deal, So those days were rough and tumble days, and Connie was representing the trade in that case, and I was representing institutional creditors. And we were at loggerheads, I guess, in the meetings. And then after one meeting, Connie called me and he said, "Why don't you be co-counsel with me so we don't have any problems?" Which in those days wasn't done. And I said, okay. So we wound up being co-counsel in the case, and the problem was resolved.
Frank Kennedy?
Frank Kennedy was a scholar, taught at the University of Michigan Law School, I guess, in his career. He was a reporter for the original commission, I guess, for the 78 Code.
Right. He was.
And he was a very studious, careful draftsperson. He was, for a long time, the secretary of the NBC, would do the minutes. He was just a shy kind of personality, not the kind of person to be a great practitioner, but he was just a wonderful scholar, a wonderful lawyer, a great draftsman. So just a pleasure to work with. Larry King was a friend, and he was, for a long time, counsel to this firm, and was counsel to Sears and Morris Neuberger. He was in the class of '53, along with Dick Lieb, and they were both on law review when I got on the law review, and we became friends over the years. And he was a wealth of knowledge for this firm and its associates and partners on the code. He was one who combined the code knowledge and the bankruptcy law knowledge, and he was phenomenal. A gentle, amazing person. I don't use the word saintly on a lot of people, but he was a saintly kind of person, and brilliant scholar. He would get impatient with special interest stuff. He would get angry at things, but it was always on the side of the consumer, always on the side of what's right. And so he was a wonderful guy to work with. Again, not a typical kind of practicing lawyer. He really was a scholar and loved the legislative end of it. And he was active. He was chairman of the legislative committee at the NBC for many years, till we managed to get younger people involved. But just a wonderful person, and is missed.
Oh, yes.
His speech at the ABI, the AB,
At the college.
at the college, the year before he died, the year he
Oh,
died, was an amazing speech.
magnificent.
Yeah.
How about Barney Shapiro?
Barney Shapiro, to me, is the consummate practitioner. If I had to have somebody chiseled on Mount Rushmore, I would chisel Barney Shapiro. I mean, Barney is a Californian. He's a brilliant lawyer, marvelous orator, wonderful person, just amazing. He's still alive out in California, not in great health, but whenever I was in a case with him, he always knew what was the right thing to do. He always knew how to do it, and he always could go to court, be effective in court, be effective in papers, be effective in a conference room. He was just a wonderful, wonderful, all-around threat as a lawyer.
Mr. Rosen, could you tell us your opinion on how successful Chapter 11 has been?
I think Chapter 11 has been very successful. I mean, I think it's a fail-safe. It's the default thing that happens when a company can't go on. And as such, it enables companies to survive if they deserve to survive, and I think it's worked quite well.
Let's try that once more and just address the whole group. You can say to George, I think Chapter 11, and then just
And then turn?
because otherwise I just have a profile shot if you'd like that.
Okay.
George, ask him once more, just a second. And ready, set, action.
Mr. Rosen, could you tell us your opinion on how successful Chapter 11 has been?
I believe Chapter 11 has been very successful. I think it's a fail-safe mechanism when a business can't go on. There's a possibility of saving it. You need some kind of vehicle that creates that possibility. It needs to be a judicial vehicle. It needs to be a flexible vehicle. I think it pretty much qualifies. It's not to say there aren't things you can tinker with. It's not to say it isn't abused in some ways. But overall, I think it's excellent. I think other countries in more recent years have looked to the American Chapter 11 as a way to avoid the kinds of shutdowns that occur in other places where it just happens in an arbitrary way. So I'm very much in favor of it, and I think it works pretty well.
I don't think we had mentioned earlier, but yeah, you've been an adjunct professor at NYU teaching bankruptcy and corporate reorganization for a number of years. And in fact, as you may or may not recall, I was one of your students probably a few more years ago than I would care to remember. And I want to just ask you a couple of questions about some of the changes in practice in recent times and your view of them. We've seen that Chapter 11 more and more frequently is being used as a sell mechanism rather than a true reorganization of the business. And I wondered if you had any thoughts on that, if that was something that you envisioned as a possibility when Chapter 11 first came in, and whether you think that's good or bad?
I think we realized that the possibility was there, but we didn't think it would become as much a popular kind of way to go or to try to go, as it's become. And I think Harvey Miller views it as the death of Chapter 11 because too often it happens too quickly. And I think it's part of the whole business of the buying and selling of the trading of claims having become so prominent.
Well, that's a big issue too. What are you thinking about that?
Well, I think it's a good thing in the sense that it creates liquidity. I think I'm not going to say it's a bad thing. I think it's changed the world in terms of the fact that you have new players, different players with different objectives than when you had Chapter 11 with creditors who were the people who made the loans and were holding the loans and could then look to a relationship with the company after the proceeding was over. Now what you have is most of the claims are held by people who did not make the original loans. They're bought by someone at discounts. Their perception of what should be done is very different from the perception of an ordinary bank creditor or an insurance company that lent money, or a trade creditor who lent trade. And so you're dealing with a new universe of owners, and it gets dispersed very fast. There are a lot of people now doing this, and their objectives are how much money am I going to make on this? They have a very short time horizon because they've made an investment. Every time a year goes by, the number that they have to get on this claim goes up by the amount that they anticipated they would make. And so it's accelerated the process in a lot of Chapter 11s because you've got a lot of people who want things to happen fast. That's not necessarily a bad thing. And it's recently led to more of what you would call a sale atmosphere. Someone else can come in and pay more. I think it's just a marketplace thing, and I don't think it can be stopped, honestly. I mean, maybe it can be slowed down a little, and I don't think it should be stopped because liquidity is important to the people who have claims. They ought to be able to sell. On the other hand, the people who get the claims ought to be able to try to come to some resolution of the problems. And maybe sometimes sale is the best. I'm not going to go against that. So I just think it's an interesting development that has to be watched. I don't think you can legislate against it, probably. I think you just got to watch it and see how it develops.
Now, we've also seen, while you were sort of, I guess, the founder of the mega case by taking the first $1 billion debtor in, that now doesn't seem like such a large number. And I wonder if you had any thoughts on how well Chapter 11, which is the one-size-fits-all chapter, fits when you're dealing with mega cases like we're seeing in today's bankruptcy world.
I think it's okay. I mean, I think it really was more designed for mega than for small cases. I think it can be adapted to small cases, and there was some of the judges want a separate chapter for small businesses. I don't think it's necessary. I think the amendments that dealt with that probably are adequate. And I think this should work for mega cases. I don't have any problem with it. I think the act needs to be tinkered with once in a while, but basically I think the structure is sound.
And we continue to hear concerns about professionals in the process, and I wondered if you had any thoughts on that.
Yeah, I've thought about that a lot, and I haven't got a great solution. But I always felt, particularly in cases where you have multiple debtors with conflicting interests, subsidiaries, parents, loans were made into company, different balance sheets, different creditors, you get the problem, how many creditors committees you're going to have, because they're all different. And I always felt that you should try to have one, but if necessary to resolve conflicts, you would have to recognize that you might have to have 2 or 3, but there's a limit. And my problem is if you have 3 or 4 committees, each of which has lawyers, accountants, and investment bankers, and other professionals, you're going to start running up fees of an enormous amount. And I never figured out how to solve that problem. As far as I came, and nobody seems to agree with me, is that maybe you could have one accountant for multiple committees and just tell them that they're acting as fiduciaries for all 4 committees, that accountants don't have to be advocates. I don't know that you can do it with investment bankers, but I might try. I think you need separate lawyers for everybody's got a separate interest. So I think something can be done in that area to avoid the massive expense. On the other hand, the cases are so big now that you can almost justify the expenses given the dollars involved. So it depends on the size of the case, it depends on the complexity of the issues, and I would personally like to see some flexibility worked into the system where maybe you could have one professional deal with more than one committee, for argument's sake. Unless an actual conflict involves, and then somebody goes and gets another one. I mean, so I see that as a possible problem, and that deserves thought.
Mr. Rosen, what do you think is the future of reorganization?
I think, unfortunately, it has a great future. I think a lot of companies in this country are in trouble at this point, and there are periodic times when you need to have a reorganization statute to deal with the problems, and I think we're approaching a time when that's probably true. And you've got a lot of lawyers waiting for it to happen. But I think it's just a necessary kind of escape valve when pressure builds up too high and things go wrong.
Let me ask you this question. You have had, during your life, in addition to all these successful cases, you have a lovely wife, Phyllis. You have 3 sons, of which one, Adam, teaches in our LLM and bankruptcy program, a daughter, and 8 grandchildren?
9 grandchildren. 9 don't leave anybody out. Don't leave anybody out.
And how do you did you manage to balance the workload and your family obligations?
With great, considerable difficulty. I think it was hard. I think I was lucky. My wife was very understanding and remains so. My kids, I think, suffered somewhat for it, honestly, and I hope they forgive me. But I retired now 8 years ago, 9 years ago, and I've been able to spend more attention to my children, my grandchildren.
Sounds good.
I think the biggest problem I had in my life was balancing work and the family. And I don't have significant hobbies. I never spent a lot of time doing anything. I think work and the family were my life. So that was enough. But I was very fortunate. I mean, had 4 healthy children, 9 healthy grandchildren, and that was a great blessing, and I couldn't have wished for a better life. And I had a great career. I got recognition, which was nice, and so it's a good story.
Right, and we really appreciate very much giving us this opportunity to speak with you. In looking through some of the background, there were many wonderful things said about you. I think this was in connection with the time you received the Service Award from the American College of Bankruptcy. And they described you as exhibiting talent, intellectual honesty, intelligence, objectivity, personal dignity, and infectious goodwill. And I think this interview, this discussion, proves that 100%.
Thank you.
Thank you very much.
Thank you. Thank you all. I really appreciate you doing this, and I appreciate the safari you've undertaken to speak to other people as well. I think it's a great idea.